Okay, there we go. So welcome everybody to the February meeting of the PRC. It's nice to see you all. We have a few regrets. I'll tell you who they are. Dick, Rob, Andrea, Brendan, and Peter is going to be late, but he will be joining us, and he'll be constructing the minutes from the recording, which is what he usually does in any event. So that's great. And we have two visitors today, but we'll introduce you ladies when we get to that part of the agenda. All right, so the first thing we need to do is we need to have a motion for the approval of the agenda for today. So John moves, seconder, Howard, all in favor? We'll take it that the iPhone and the call from Chicago agree as well. Okay, thank you.
I agree.
Yeah, thanks, Aaron. Okay, and then as well, the minutes of our last meeting. So can I have a mover to accept those minutes? Stefan, seconder, John, and all in favor? Great, okay. Thank you very much, everybody. So that's super. Okay, so moving on to news and announcements. There aren't any news particularly except for items on the second page, and the very first one is the brief on bail reform. So I'll turn this over to Howard to run that part of the program and to introduce the attendees.
Thank you, Miles. We have with us today our two Pro Bono Student Canada students, so the two students assigned for the academic year that is quickly coming to an end. We have Becky McRae, who you may recognize was working with us last year as well. We also have Olivia Gauthier-Mouton. I hope I'm pronouncing that correctly, Olivia. These two extraordinary young lawyers in the making are both in their third year at the Faculty of Law, University of Ottawa Common Law program. So they're coming towards their end with bar admission exams looming up in the near future, and then articles. And they both, I think, have acquired articles for the coming year. I think they're on their way to illustrious and storied careers in law. I'm going to ask them to introduce themselves a little bit, but I just want to say that the Pro Bono Student Canada program, which CCJ has been working with for some years now, always produces exemplary candidates, people with incredible background experience and broad view from a justice and social justice perspective. And Becky and Olivia are two very good examples of that. My goodness, when I think of what I was able to deal with in third year law school, I'm put to shame. These two are extraordinary and stellar. Why don't you guys take a minute just to introduce yourselves a little bit, your interests and where you come from, and then we'll start in on the brief. Becky, do you want to start?
Yeah, certainly. So thank you, Howard, for having us today, and thank you, everyone. It's a pleasure to be back. So I have a background in criminal justice and public policy. I did my undergrad and my master's in it. I did my master's thesis studying probation conditions, so I'm really eager to dig into bail. That's our brief today. So I'm really excited, and I'm hoping to continue my career working in policy, but also criminal justice. I'm going to be articling in the criminal defense department starting soon. So I'm looking forward to that. And thank you so much for having us today.
Olivia, tell us a little bit about yourself.
Good afternoon. Sorry, my brain was going to say good morning. So my name's Olivia. I didn't have, I guess, a straight into the crim trajectory as Becky did. I did an undergrad in English and philosophy and creative writing. So a little bit of a different route, but I'm also been working for a criminal defense firm, a sole practitioner here in Ottawa. And so I've had quite the interest. I also have quite the interest in bail. I've been doing a lot of research into bail in the last 2 years in different courses and then through this project. So I'm very excited to be here today. Thank you again for having us.
Well, thank you both. I must say philosophy and creative writing are very important for law, as we all know. So anyway, let's turn to the brief on bail. And I must say, this has kind of been a couple of years in development. You've heard Olivia talk about her background. Becky's been working on this with us last year as well. It's a topic that's of great interest, I think sometimes characterized by more heat than light in the media these days. What I want to say about this brief, and I'm going to get to our two students to introduce it in more detail, but unlike our usual CCJ briefs, it's not specifically aimed at a bill before Parliament. The brief does cover quite fully Bill C-48, but that bill has now become an act. It has passed and is in force as of the beginning of this year. We also touch on Bill C-75, which became a statute in 2019, I believe, which had a number of things in it, but a component on bail in response to the SEC decision in Antic. They're quite different, the two bills. One sort of tries to approach bail in a fairly progressive equity consideration perspective. The other one is kind of a retrenchment, dealing mostly with mandatory provisions of reverse onus. But at any rate, this brief focuses on broadly bail reform with the perspective that we really need to do some good bail reform, not little pieces in response to public controversies. My view is that rather than targeting this brief to parliamentary committees studying bills as we usually do, our audience for this brief ought to be the Minister of Justice, the Minister of Public Safety, and the Prime Minister in an attempt to urge the Department of Justice and the government generally to get on with more evidence-based, broad-based approach to bail. The problems with bail aren't going away. My own view is the public doesn't understand it. The public thinks when someone's arrested and taken into custody, they are in fact guilty and shouldn't be released. And they see a bail release as someone getting out of jail free. But anyway, we can talk more about that. I'm going to turn to our two expert students and remarkable young people to introduce in a little bit more detail the brief before you. Because it was only provided a day or two ago, we are happy to come back at the next PRC meeting if people want a chance to chew on it as well. But let me, without further ado, turn to Olivia and Becky. Who wants to start off?
So I'm going to start off, and then Olivia, feel free to jump in if I miss anything, and then she'll do the second half as well. So to begin, as Howard was mentioning, we do understand that the bill has passed, but we wanted to provide some comments and some analysis into the bail reform as a whole. So this paper provided some of those comments. So as noted, Bill C-48 has been passed. It received royal assent December 5th, 2023, and came into force 30 days later. And it has made several amendments to the criminal code with the address of targeting repeat offenders, weapon offenses, gender-based violence. And it also focuses creating a lot of reverse onus on bail provisions for any person charged with those serious offenses, use of a weapon, or has been convicted of a previous offense before. So as we all are aware, the media is very into bail reform, reporting all types of things. So we did find this issue is very relevant today. It also, Bill C-48 expanded on the current reverse onuses pertaining to firearm offenses as well. And it also adds express consideration for the courts deciding whether or not to grant bail. So we started the brief by looking at kind of the buildup to this bail reform. So we started with looking at Section 11E of the Canadian Charter of Rights and Freedom. So we understand that it is really important that an individual charged with an offense does have a right not to be denied reasonable bail without just cause, and the presumption of innocence during the pretrial. And then also looking at Section 51510 of the Criminal Code, the three grounds of denying bail with the primary, tertiary, and secondary grounds. And then we kind of went into an analysis looking at some of the jurisprudence, such as RV Antic, that came out to focus on the consideration of bail reform in 2017. So this legislation ensured that bail provisions are applied consistently and fairly, as there was an over-reliance either on cash bails or surety. So this provision helped try to codify that latter principle. So Antic provided guidelines for courts to consider, such as the presumption of innocence defaulting to unconditional releases. But then as we move towards presently, we look at Bill C-75, which was introduced in 2019. And that one's more targeted towards the modernizing and streamlining the bail regime while ensuring public safety and minimizing increasing public confidence in the criminal justice system. As we've seen the media, we've had some incidences of individuals getting released during bail and reoffending. So it has been high in the media. So this provision increases courts' discretion as well as police when imposing conditions of release. It also targeted vulnerable populations when making bail decisions, such as Indigenous populations. So when we looked into the analysis, we started with the current statistics of bail. So following up the decision in Antic, we found in 2021, 2022, nearly 70.5% of individuals in Canada's provincial and territorial jails are being detained. So these are individuals that have not been found guilty, but they're still in custody awaiting trial. So that means roughly in 2021 to 2022, that's 14,415 individuals that have not been found guilty, still awaiting trials. So the presumption of innocence and people being denied their liberty while awaiting bail. So we were looking at the statistics of kind of what is the issue. And then we went into looking at the strengths of the bill. So having a proper functioning of the bail system is imperative. Bill C-48 does target repeat offenders, as that is a concern to society and the justice system, by creating reverse onuses and making it more difficult to obtain bail while intended. It also expressly requires judges to consider the accused person's history of violence and community safety concerns. However, when we looked at the weaknesses of the bill, we felt it was rushed through the House of Commons with little debate and little consideration of its impacts. The proposed amendments, we felt, didn't seem like it's going to be an appealing solution to the current problems that we have in our bail system, and the consequences may do more harm than good. We also felt that it lacked empirical evidence-based research to support their premises. So these amendments will likely cause an increase of number of people denied bail, and they'll be held longer in custody. So those are some of the concerns that we were looking at. And then we went into an analysis of the presumption of innocence and the reverse onus and what that will occur. So Section 11D of the Criminal Code reflects our beliefs individuals are law-abiding members of the community until proven otherwise. But in a reverse onus proceedings, the presumptions the accused person is detained while awaiting their trial and having to prove their innocence. So we're looking at some of those issues there. And now Olivia will speak to you about the dangers of fast-tracking these bills.
Sorry, I just want to make sure you guys can hear me. Yeah, good. Okay, perfect. So we wrote about the dangers of fast tracking the bill. One of the big considerations, we looked a lot at commentary from mostly defense attorneys in Ottawa and surrounding, and their sort of comments about how understudied this bill was, and that it was sort of a push through with what we refer to as unsubstantiated assertions that it will provide these benefits or protections to the public. There's a direct quote from the Minister of Justice who says that this legislation will address public concerns regarding violent offenders and weapon-based offenses, but they were never able to provide any evidence of such. It was never studied about what would actually happen when these sort of laws were put into place. Another thing that we sort of looked at really just kind of came up to the fact that there was no evidence to back up these assertions. These were just sort of blindly stated, in our opinion, during the bill considerations, and it wasn't really presented with any sort of, again, like Becky said, empirical evidence. That is really what it came down to. There was nothing to justify the additional reverse onuses, and what it really boils down to, in my opinion, the most important part of this brief is the equity considerations. Implementing new reverse onuses will just deepen inequities in the justice system. We really sort of stand by the opinion that those who are racialized, marginalized, who are of lower class and Indigenous specifically, are more likely to be remanded or to be held without bail. And this is just going to sort of double that amount. again, specific data shows that racialized individuals, specifically Black accused, are statistically more likely to be detained pre-trial. And there's a comment here we have specifically about Indigenous women that I think is really important, coming specifically from an Indigenous lawyer, part of the Indigenous Bar Association, where she talks about part of Bill C-48 refers specifically to domestic violence and a reverse onus on somebody who has been charged twice, like a second time with domestic violence, or has previously received a conditional discharge for a domestic violence offense. And we really wanted to consider the practice of dual charging, which I'll explain really briefly just for a basic understanding. But in a domestic violence, if police are called to a home about domestic violence and they don't know who the perpetrator is, or if there's accusations of violence on both parts, they'll often charge both the man and the woman in a typical sense. And this ends up being, with a lot of women in violent relationships, being swept up into the criminal justice system. Again, Indigenous people already do not receive bail at the same rate. And a factor that we found really interesting, talked about during by Kim Pate, I believe, in the discussions of this bill, is that women are more likely to use weapons in these sort of interactions, whether it's like something accessible like a kitchen knife or a frying pan, to defend themselves during a domestic dispute. And then they'll likely be arrested for such, and it'll be even a higher offense because it'll be an assault with a weapon, a threatening with a weapon, that sort of more violent offense, even though in that situation they are technically the victim. And then when you're held without bail on a reverse onus, as happens to a lot of these Indigenous women, they're more likely to plead guilty to be able to get out and return to their homes or return to their families. And it just ends up being this like awful cyclical situation that we just think this sort of bill and the way bail reform is heading is just sort of repeating, and we're just sort of doomed to repeat. So that's something we really wanted to speak to. The other thing, of course, is pretrial custody has very poor adverse effects on mental health. Again, can lead to individuals pleading guilty, even if they're not factually guilty, just so that they can get out of prison. Again, employment, family relationships, and just the overall treatment and health risks in these remand facilities should be of the utmost consideration. We then moved on to a brief comparative analysis. Just with the size of the brief, we were only really able to touch sort of lightly on these, but we looked at two countries that have, I guess, similar systems, but different approaches to bail in the criminal justice system that we have. The first being Norway, one that we thought was really interesting because everyone always speaks to the brilliance of the Norway prison system and or the way it's very different from ours. But something that's really interesting about Norway is they don't have bail, like at all. They have most of their offenses you're released on completely, and then some mostly violent offenses or drug-based offenses, because Norway has a really, really bad issue with drug trafficking right now, apparently, something we discovered during our research of this. But those are the only ones that they are automatically remanded into custody for. But a huge difference, of course, is that in this, they're given full access to their family the entire time that they're in custody, and they have access to a government paid lawyer. To sort of the different living spaces of incarceration in Norway versus Canada obviously do make a slightly different consideration there. The next one we looked at was Australia, who has a similar structured system to us and are actually dealing with basically the very same debate on bail reform right now. They've had additional public cases of people being let out on bail and committing a violent crime and tightening their bail restrictions. And there's a lot of Australian scholars who are emphasizing this issue of increasing pretrial incarceration and how it leads to health risks of the accused, both physically and mentally. Another consideration being the economic expense of increasing incarceration. The more people we hold, the more people we have to pay for, and just the impact, procedural fairness, and due process. That does bring us to our conclusion, which just sort of wraps up the points that our opinion of Bill C-48 is that it lacks empirical data to support that the changes made will better protect the public and reduce violent crime. And that is of our opinion that these amendments actually may exacerbate the issues faced in the bail system, and that expanding on the reverse onus is only going to make it more difficult for some individuals to obtain bail, and increase our remand population. We then provided 6 recommendations, which I can walk through briefly. The first is for the Department of Justice to conduct a thorough study of the assertions made in the amendments of C-48, that C-48 will decrease violent offenses, and to identify any evidence that supports these assertions. The next is that an independent review should be funded of possible charter implications and constitutional violations of the charges, of the changes enacted by Bill C-48. When viewing the charter statement attached to C-48, it only considers Section 11 of the charter. It only considers the the presumption of innocence. It doesn't consider any possible Section 7 or Section 15 implications. And with our opinion that it'll have quite an impact on racialized and marginalized individuals, we do think a Section 15 analysis would have been appropriate. And with these charter statements being done by the same minister who proposes the bill, we do find an independent review would be of importance. The next is funding for Statistics Canada to improve the collection and analysis of data relating to bail in Canada, as it is difficult to find very specific statistics that aren't sort of more generalized. And so a better understanding would obviously be helpful. The next is that we should undertake a broad-based initiative to directly address rising concerns regarding remand populations across the country and how to provide alternative bail options, such as increasing bail supervision programs or community-based programming. The last 2, the first one focuses on, there's provisions under the Youth Criminal Justice Act that sort of limit when a detention is justifiable for an accused, and it's just sort of looking at those and how they can be implemented into the regular criminal code. And the last one is my personal favorite, is a 2-tiered bail system. If the goal of Bill C-48 is to detain more violent offenders pre-trial, we don't think it's reasonable to just keep upping the amount of people held without bail, but instead there should be a better balance. And a proposal of such is to focus on releasing more non-violent offenders from pre-trial custody and not remanding them as much. That is everything we have. If you guys have any questions, we can answer.
Well done.
Yeah,
Well done.
that was excellent. So what I'm going to do is, as you ladies probably know, this is being recorded and it goes out to all the members of the association afterwards. I'll make a point in my email with the link for the recording that this is something to really watch and pay attention to. So hopefully our membership has the opportunity to listen to your excellent presentation.
Just I mean, I think the presentation speaks to it all and was beautifully done. 2 things that may not be as clear from what we have written there is that the YCGA does better on bail than the adult system does, just as the YCGA does significantly better on issues of imprisonment as well. Judges now retired, I think Justice David Cole used to and still does advocate that what's wrong with the adult system is it needs to be more like the youth justice system. So I wish Dick was with us today to talk more about that. But that recommendation is an attempt to say, what can we learn from the youth justice system that has imprisonment, rates of imprisonment, and rates of bail detention significantly lower. And under the YCJA, it was going up as it is in the adult system, but they kind of got a hold of it. And it has to do with some of the provisions. The other thing I'll add to that is we didn't really remark on this in our draft because we didn't really have good evidence on it. But a number of criminal practitioners say that an added negative feature of C48 and like-minded changes is that whether or not it increases the remand population, and that's what it's intended to do, in addition to that, it increases the complexity of bail hearings, which can only delay them. And I have anecdotal reports from defense counsel in Ottawa that I know that say instead of a couple of hours or an hour of a bail hearing, some of them are scheduled over days. And this is something that the students and I may hopefully be able to follow up on. Becky has a particular interest in that with a major research paper. But if bail hearings are now going over days, you can imagine what that's doing to justice system resources at a time where delay is huge. Now, we haven't picked up on that thread in the brief, partly because there's so much already in there, and we didn't have any good data. Frankly, there's nowhere near enough good data, but I think everyone, including the Minister of Justice, agrees that Stats Canada and the federal government need to collect more. But those are additional factors. Where we're going in so-called bail reform is not a good direction. And this is why we think collectively it would be a good thing for CCJ to be on the record to say, you can do better than this. There are areas to pursue. They're more humane, more thoughtful, more evidence-based kinds of reforms that can be made if we stop listening to the bandwagon reaction to a horrible murder of a police officer in Hagersville. But these are particular events and their causes are complicated, including the inability of the police to detain the individual who was subject to a warrant. So anyway, there's a lot going on, but we're arguing for a more evidence-based, more broad approach to bail reform. And I think the brief is quite timely for that reason. And Miles, I really support your comment that it would be worthwhile to give the membership of the PRC, some of whom are here today, a chance to sort of review today's tape and think about this and come back, and we can have a further discussion about the brief, if you will, at the next meeting in March. So back to you, Miles. Thank you.
Oh, thanks, Howard, and thank you very much to Olivia and Becky. We're moving on through our agenda. You're more than welcome to stay with us for the rest of the agenda. It usually doesn't go much past 1 o'clock, so we won't keep you too long if that's your wish. The next new item on the agenda is something that I posted. It's an article in the Winnipeg Free Press on Bill C-40. Irving tells me that he couldn't open it. He required a subscription to that particular media, and so unfortunately, I guess that would be the case for everybody. I received it from,
I don't think. No.
I'm sorry, Irving?
I wasn't able to get into it, Miles.
Okay, I appreciate that. So I don't know whether anybody else was or not. I received it from Wynne Waywear, who's the Chief Administrative Officer of Innocence Canada. So for whatever reason, I was able to access it. So what I'm going to do is I'm just going to read a couple of excerpts from the piece in the Winnipeg Free Press. The title of the article is "Tactics Delay Justice for Canadians Already Denied Justice," and of course this deals with Bill C-40, which CCGA supported, and I appeared at a parliamentary committee in November dealing with it. So from the article, it says the following: from all available evidence, the Conservatives support C-40, but remain committed to keeping it in committee. There is no indication the bill will go to the Senate anytime soon. On Friday, the last day of the current session of Parliament, the bill was still subjected to a filibuster by Tory members of the Justice Committee. There is no forecast now for when it will get to the upper house. Why would a bill with such noble intentions be delayed at the Standing Committee on Justice with no end in sight? Like many other pieces of legislation currently before Parliament, C-40 has been caught up in the Conservatives' war against the federal carbon tax. Conservative leader Pierre Poilievre threatened in early December to table thousands of amendments to legislation and use other procedural tactics, including the filibuster, to create a parliamentary gridlock unless the Liberals scrapped elements of its controversial carbon tax. In particular, Poilievre wants the tax removed from all sources of home heating, some farming activities, and all First Nations. The Tory strategy on C-40 has not only been denounced by the Liberal government and NDP opposition, which has an agreement to support Prime Minister Justin Trudeau in the current session of Parliament. Important advocates for the wrongly convicted are also expressing their concern. James Lockyer, Canada's foremost lawyer in the area of wrongful convictions and a representative of Innocence Canada, said he is more than alarmed that after decades of lobbying for an independent commission, C40 is being sacrificed for a political campaign that has nothing to do with the fate of the wrongfully convicted. We are very disturbed and troubled that this legislation, which is so desperately needed, is going to be derailed by a filibuster, Lockyer said. We would ask the Conservatives to rethink their strategy as soon as possible. Okay, so I put that out there to the PRC. Anybody have any questions or comments on that particular piece?
Miles, I'm going to talk about C40 in my report on this Justice Committee, the House of Commons Justice Committee as well, but I'll hold off on that. So whenever you're ready, we can move. That's a good segue to it.
Oh, good. Anything else on this? All right, so is there any other new business or news that we want to bring to the committee? Okay, good. And then
Miles, sorry, Miles, just one thing. I wish Andrea were here, but this week Andrea had shared with me a very interesting website that I was unaware of out of England. It's called Mapping Solitary Confinement, and academics in England have put together a comparative piece on solitary confinement, I think covering maybe 47 countries. There's a larger number of reports because in Canada, for instance, they have a report on the federal government and then a report on many of the provincial territorial jurisdictions. I'm going to put that in at Andrea's request and quite happily at our newsletter for this coming Sunday. But have a look at it. It's a website. It's phenomenal. The report is amazing, giving just the most comprehensive comparative view on the use of solitary confinement around the world. And so I just wanted to highlight that for you. And thank you to Andrea for bringing that to my attention. So keep your eyes peeled for that.
excellent. Thanks, Howard. All right, so let's move on then to business arising. So we're going to have to segue back to Howard. So we're dealing with the justice-related parliamentary committees. The first one is Commons, Justice, and Human Rights, and that is Howard. Thank you.
Thank you. Now, I know we've taken up a fair bit of your time with the brief, so I'll try and make this a short report, which for me, of course, is not easy to do. I actually missed a couple of these reports at past meetings, but I'm not going to go back before the Christmas break. But just to let you know, there have been 4 meetings since the new year. The committee is busy as ever. One of the things they've taken up in the last 2 meetings is something that they're referring to as the 2023 Corrective Act. This is a part of it's a new title for the Miscellaneous Statute Law Amendment Act program, which is by its own terms limited to anomalies, inconsistencies, and errors, i.e. non-controversial amendments to federal statutes. So the program is not of much interest to this committee, being non-controversial. A number of the amendments proposed would not even be justice legislation, but it's non-controversial corrections. But it's nice to see this program was started in 1975. It's nice to see it getting back on together to correct some of those glitches, many of which exist throughout the federal statutes that themselves are not of sufficient priority to justify bills. So it will be an omnibus bill once put together. But anyway, it's an interesting process, so pay attention to that. There were a few other things. There was an emergency meeting requested by Conservatives attempting to get hearings going on the problem with judicial appointments. The motion, I think, by Rob Moore was defeated, so that won't occur. But the Conservatives wanted to call the Chief Justice, the Prime Minister's office, Richard Wagner, former and current ministers, to explain the so-called delay in appointments. But we've seen the new minister try and move on quickly with that. It is a topic of concern. That motion failed in committee, so the committee will not be studying that per se. There were some other little bits and pieces, but the thing more important in all this is Bill C40, as Miles has indicated. The short title of that bill is the Miscarriage of Justice Review Commission Act. David and Joyce Milgard, we've been watching this for a while, and of course, Miles gave excellent testimony before Christmas on this bill. To Miles's point in the article, this bill has been considered in whole or part of at least 9 meetings going back to October of last year. It's really been considered fully. I'm happy to say that the bill was finally passed by the committee, although with amendments. So on February the 1st, the bill was adopted on division as amended, and the bill has been reported to the House of Commons, I think on February the 7th. Yeah, February the 7th. So I'm just looking at my report. There are a list of amendments made, many of which seem to me to be relatively minor, having to do with trial court, Court of Appeal, and Supreme Court of Canada. I think Miles may know a whole lot more about this, so I'm going to hand it over to him in just a second. The 2 amendments made that seem to me to be worthy of most attention is, one is adding a jurisdiction to the commissioners to make recommendations about systemic issues and to make those to the Law Commission of Canada, federal, provincial, territorial committees, federal departments, agencies, etc. So that recommendation power is in addition to the review power. The other thing maybe of interest to us is there was an amendment that would direct employees of the Commission to notify Correctional Service of Canada and Parole Board of the importance of ensuring that people who apply for a review of their convictions, and I'm quoting here, do not experience barriers to or exclusions from programs, services, or conditional release processes as a result of making an application for a review of their conviction. So, but Miles, you're much closer to this bill than I am. I'm going to stand down here. Anything to add on that?
I just simply say this, that during the course of the hearings and the testimony given by both Harry Laforme, who is a former Court of Appeal justice in Ontario, his committee with Justice Juanita Westmoreland Traore is what prompted the bill being coming before Parliament. It was his and her committee work that did that. They had a number of recommendations, mostly put forward by Harry and James Lockyer and what have you. They had a lot of amendments that they wanted to see, basically, that weren't actually incorporated at the end of the day. But having said that, again, everybody is pleased that at least it's moving forward. So, the James Lockyer's comment, he made this at the committee, was, even if you don't make a single amendment, please put this in place. So let's get the institution created, and then we can tweak it whatever we need to do going forward. But at least let's create it and get it established. And so, so thanks to Howard for bringing that to our attention. And again, there's lots of other amendments that are pretty important for the purposes of it running as efficiently and in as enlightened a manner as possible. But we'll take it, as far as we can get. And and the only other fear that we have, we talk about this at Innocence Canada back and forth, is that with Singh threatening to abolish the arrangement with Trudeau if pharmacare isn't enacted in a timely manner. What we're most terrified of course, is an election, because an election would and if the bill's not enacted, and if the Liberals aren't returned to power, we have absolutely no faith whatsoever that the Conservatives would reintroduce the bill and have it go through a process again. So everybody's just holding our breath, waiting for it to continue going through the process for third reading and then off to the Senate and get it enacted. So anyway, thank you, Howard. I appreciate that update, and that's at this stage of the game where everybody is fingers crossed kind of thing. Okay. Anything more for the committee? No?
That's all from me.
All right, thank you very much. Okay, moving on. The next committee is Public Safety and National Security. Rob couldn't make it today, but he did send me an email. So here's what he just wanted the PRC to be aware of. So SECU met 4 times since our previous PRC, each meeting being about Bill C-26, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments. In my opinion, this bill and the associated SECU discussions are not relevant to the work of the PRC. Okay, so that's Rob. The next committee is Brendan on Legal and Constitutional Affairs, and Brendan did send me as he always does, a report, so I will read it for the purposes of the record. This report was generated by Brendan for today. This is a report to the PRC on the activities of the Standing Committee on Legal and Constitutional Affairs. The committee met twice since our last PRC meeting in January. Both meetings were on the topic of Bill S-230. Another meeting to be held this week will conduct a clause-by-clause review. The committee will then begin reviewing Bills S-250, a bill criminalizing non-consensual sterilization, and Bill C-291, a bill changing wording in the criminal code surrounding child sexual abuse and exploitation material. Of note, Senator Pierre Boisvenu is retiring and will no longer be on the committee. So S-230, the committee continued its consultations on this bill. Various witnesses testified, including Ivan Zinger, Correction Investigator of Canada. He said he was somewhat supportive of the bill, caused the bill a bit aggressive in its oversight, but says this could be a reasonable way forward, given rampant policy implementation failures with CSC. Various prison advocates for the St. Leonard Society, the West Coast Prison Justice Society appeared, generally supportive of the bill, especially of judicial oversight of SIUs and other segregation methods. Several mental health experts appeared, Mental Health Commission of Canada, generally supportive of the bill. Law professors and lawyers, including the Canadian Association of Black Lawyers, were very supportive of the bill. And Jeff Wilkins, National President of the Union of Canadian Correctional Officers, was not supportive of the bill. Notably, while the correctional investigator was not championing this legislation, he felt it may have a positive impact on addressing issues his office has highlighted in the past. Nevertheless, he was unsure if the bill would lead to true improvements, due in part to culture resisting change within the CSC. Significant concerns about insufficient resources for this bill came from the union, as well as some mental health representatives. Resources for judicial oversight of prison cases was also underlined as an issue with the bill. One witness, who was a psychiatrist, spoke of the importance of being selective in speaking of mental health issues because they are so varied and require vastly different responses. Concerns were raised by witnesses about who would have responsibility to monitor a detainee transferred to provincial custody, as well as who may be responsible for their potential release, i.e. federal versus provincial authorities, and a suggestion that a remedy for abuses or unfairness in the administration of prison sentences could be a sentence reduction. So that was Brendan's report. And the last report on human rights in the Senate, Dick isn't here today, so we do not have a report in that regard. Any questions or comments about what I've read into the record? Okay, thank you. All right, moving on. So there is, that takes us, there's nothing other than waiting briefs. That takes us to bills under consideration. Firstly, in the House of Commons, the government bills, Brendan asked this last meeting to add Bill C-20 into our agenda. So we've done that. So it's an act establishing the Public Complaints and Review Commission and amending certain acts. And this deals primarily with the review and replacement of the Civilian Review and Complaints Commission with respect to the RCMP. So that's now on the agenda, and it's currently had second reading as at November 2022. So there hasn't been any activity for quite a while. And Bill C-62 received its first reading on February the 1st of this year. It's an act to amend the criminal code dealing with medical assistance in dying. So everybody's probably pretty familiar with this. It's very, very common in the news. So what's happened here, and it's still a second reading, but essentially the amendment was put forward to delay the implementation of medical assistance in dying as it relates to the underlying condition being mental illness. Right, so that's been put over to March 17th of 2027. And the media reports that I've seen on that basically see this as a function of putting it over for such a period of time as bringing an end to a great degree to mental illness being the sole condition or the sole underlying condition with respect to medical assistance in dying. Any comments or concerns regarding that? All right, private members' bills in the Commons. There was no change in any of the private member bills in the last meeting, with the exception of the introduction of Bill C-373, an act to amend the criminal code with respect to promotion of hatred or anti-Semitism, And this amendment amends the criminal code to eliminate as a defense against willful promotion of hatred or anti-Semitism the fact that a person in good faith expressed or attempted to establish by an argument an opinion on a religious subject or an opinion based on a belief in a religious context. So that's in that first reading on February the 1st of this month. Okay, in the Senate, there are no government Senate bills to review. And with respect to private members' bills, Bill S-231, which deals with, and we talked about this before, deals with the expansion of collection of DNA, put forward to a great degree by the police, the Association of Chiefs of Police across the country. That is in committee after second reading, December 2023. So this is a bill, again, it's a private members bill, but it's a bill to, basically extend the situation of the circumstances where, potential, at least, people who are accused, their DNA can be collected and put into a database to increase the database for the purposes, of course, of investigation for the most part. And that is the only change in private member bills in the Senate. And that brings us to the end of the meeting. Does anybody else have anything else for the benefit of the committee? Okay, all right. Well, our next meeting will be on the 12th of March, 2024. Happy Valentine's Day, everybody, tomorrow. Take care.
Thanks, Miles.
Yes, Becky and
Hey,
Olivia, thank you very much for attending. Very much appreciated.
Sorry, before we sign off, Howard, Becky, and Olivia, thanks again for the brief. There's a couple of comments. Would you welcome them or?
Yes, absolutely.
Okay.
Do you want to, I mean, there's a point of order, I guess. I don't know if you want to send them to Miles as the chair. In a sense, we've done our work and handed it to CCJA.
Okay.
The final version is up to the PRC and the board. So, I mean, you guys could completely rewrite it. We're aware of that for this to be a CCJA product, it has to have the approval of CCJA. But we're certainly open to comments. John, why don't you send comments to Miles and copy to me? We could do some further work between now and March if that was the will of the committee, or we could just simply leave it in your hands. We of course don't want to rewrite things that we think should be in there, but I know your comments would be helpful and well informed. So my suggestion up to Miles is approval is maybe send them to Miles and myself, and we can talk about next steps and whether this should be on again at the next meeting, if that makes sense.
Absolutely.
Miles?
Yep, that's great. Thanks, Howard.
Okay.
And thank you, John. I'll look for those. All right, everybody. All right, again, thank you very much for attending the meeting, and we will see you next month. Again, thank
Happy New Year.
Thanks, guys.
you. Olivia, very much.
Take care.
All right. Cheers.
Bye, Howard. Bye-bye.